Шановні колеги,
We continue our work. The topic of the next event is Donbas occupied. Our guest is Wayne Jordash, QC. Вам слово, пане Jordash.
Thank you. So I want to address the question, is Donbas occupied? So the question of whether the Russian Federation is in occupation of Donbas is a complicated issue that rests upon detailed factual assessments concerning a number of legal issues that I will outline in this presentation. Unfortunately, international humanitarian law instruments do not provide definitive standards for determining when an occupation begins or when it ends. However, it is critical that Ukraine attempts this assessment. Although a finding that Russia is in occupation will not remove Ukraine's humanitarian law or human rights obligations towards the civilian population, it will help to define what they are and will also clarify the obligations that Russia owes to civilians in Donbas and enable Ukraine to take legal action to enforce those rights and seek remedies for any violations. So in the next 20 minutes I will therefore discuss 1. The assessment of Russia's alleged occupation of Donbas and how it should be approached. 2. In the event that Donbas is occupied, what human rights and humanitarian law obligations likely remain upon Russia. And 3. The principal legal options that Ukraine might take internationally to enforce its rights against Russia as an occupying state. So I'm referring to the pictograph, and I will take you through the pictograph. It is designed to show the legal and factual assessments that will need to be made to define the question of Russia's alleged occupation of Donbas. The legal provision, Article 42 of the Hague Regulations, is where the definition for occupation emerges. Territory is considered occupied when it is actually placed under the authority of the hostile army. The occupation extends only to the territory where such authority has been established and can be exercised. As you will appreciate, that is somewhat vague, but nonetheless it is the foundation for the definition, and it is what courts such as the International Court of Justice and the ICTY, the International Court for the former Yugoslavia, and the ICC will rely. Now, it is essentially a factual question. The sole factual basis for determining the existence of an occupation is the de facto submission of a territory to the authority of the hostile army. When does it begin? How does an occupation begin, therefore? It begins when the territory is placed under the effective control of the hostile army. That's the test, the effective control by a hostile foreign army. It doesn't matter whether it's called an invasion, a liberation, an administration, or whether it in fact is called an occupation. What matters is that it is defined by effective control. The moment the hostile army is in effective control, it is able to carry out all the duties imposed by the law of occupation, and therefore it is deemed to be in occupation. Effective control should not be confused with full control. It is less than full control. It cannot be decided in the abstract. What is effective will depend on a case-by-case situation, dependent upon such things as the terrain, the density of the population, the size of the foreign army, the nature of the replaced administration, the nature of the forces and actors on the ground, and many other considerations. The best test we have for determining the existence of an occupation comes from the International Committee of the Red Cross. According to them, 3 cumulative conditions must be met in order to determine the existence of an occupation. These are the following, and I will elaborate on them in due course. 1, physical presence of the armed forces of a state in a foreign territory without consent. 2, exercise of authority over the entire territory or its parts by the foreign forces in lieu of the local government. And thirdly, substantial or complete incapability of the local government to exercise its powers by virtue of the foreign forces' presence, which has not been consented to. Let me take each in turn and try to describe the international legal principles which are applicable. 1, physical presence of the armed forces of a state in a foreign territory. Is the foreign military physically present and thus able to exert authority over the occupied territory? Put it another way, does the foreign army, by its physical presence, have effective control over the foreign territory so that it can impose its authority within a reasonable time as a result of having established its authority due to an invasion? Without physical presence, it will not be able to live up to its commitments required by international humanitarian law, such as maintaining public order and maintaining the life of the civilian population. However, the prerequisite of foreign troops on the ground does not mean that the effective control has to be across the whole of the territory, or that their presence has to be across the whole of the territory. It will vary depending upon the circumstances. For example, effective control could be established by positioning foreign forces in strategic places, which allows the occupying power the capability of sending other troops within a reasonable time to make its authority felt. So in the end, it is the ability to be able to exert authority combined with the assertion of that authority that is at the heart of the overall assessment. The second ICRC condition, the exercise of authority in lieu of the local government. The occupation requires the exercise of governmental functions. This distinguishes an invasion from an occupation. However, a majority of experts consider that the possibility of exercising control over the territory or part of it may be sufficient. There is broad agreement that once enemy foreign forces have established a presence in the territory, what counts is the ability of the foreign forces to exert authority. So, what does that mean in concrete terms? If you have some troops in the country, if you have some checkpoints in the country, if you have some personnel or strategically placed personnel in the country or in the foreign territory, then the ability to be able to move more into the territory at short notice and assert your authority is at the heart of this assessment. The third ICRC condition, substantial or complete incapability of the effect of the local government. There is no, as I've said, requirement that the entire territory be occupied. If the occupied power is still functioning in parts of the occupied territory, but these parts are cut off from the rest of the occupied territory, then the territory remains occupied nonetheless. Similarly, the fact that the ousted state or troops are able to conduct guerrilla operations, are able to move into the occupied territory and exert brief or temporary control over parts, does not alter the legal status of the occupation. It would remain occupied. So those are the three principal conditions laid out by the ICRC. Now I want to discuss very briefly, and I think this is very relevant to the Ukraine situation, two things. One, a classic foreign occupation, which is applicable to Crimea, an occupation by proxy, which is much more applicable, or may be applicable, to Donbas. A classical foreign occupation, as I've said, involves effective control. The European Court of Human Rights has used this definition of effective control to address the issue of whether a state, as a result of military action, exercises jurisdiction over a foreign territory. The European Court of Human Rights will establish this on a case-by-case basis. It examines the issue with regard to such things as the scale, the scope, and the nature of one, military presence, example, troops being located at checkpoints, troops involved in communication, troops cutting off communication lines, and so on. And two, military dependency, example, the supply of weapons and logistics into the occupied territory. And three, economic, financial, and political support. So on a case-by-case basis, the ECHR, the European Court of Human Rights, will look at these factors to assess whether a foreign state has occupied a territory. For example, in the case of Loizerdu versus Turkey, the European Court of Human Rights found that Turkey was in occupation of northern Cyprus by virtue of the fact it had 30,000 military personnel present in the territory. And it was involved in patrols and checkpoints along the main lines of communication. In the case of Ilascu and others versus Moldova and Russia, the fact that Russia had military personnel and weaponry stocks located in the area, combined with clear commercial relations between their state-controlled military institutions and those in the occupied states, were important considerations. These factors, according to the European Court of Human Rights, showed that the separate entity, the MRT, was under the effective authority, or at least the decisive influence, of Russia, and, quote, in any event, it, the MRT, survives by virtue of the military, economic, financial, and political support given to it by the Russian Federation. Obviously, there are questions to be asked along those lines in relation to the East and Russians' involvement or alleged involvement. Occupation by proxy, much more, as I've said, likely to be applicable to Donbas. Contemporary international humanitarian law acknowledges that certain situations that arise in armed conflicts may trigger the law of occupation, even if they don't fit into the traditional definition of occupation. In modern conflicts, it is much more common to have a situation where a territory is controlled by a surrogate armed force which is acting on behalf of a foreign state. The question, obviously, for Donbas is Russia controlling Donbas through surrogate armed forces? In situations like this, a state of occupation may exist. An important consideration is determining whether those who exercise control are acting on behalf of the state. Again, it's a question of fact. There are many possible examples of occupation by proxy. For example, when multinational forces act in other territories, when persons or facilities are controlled by foreign states, even though those persons and facilities are in other territory. This type of occupation may be considered to be indirect occupation. And the test here is if the foreign state exercises overall control over a separatist army, then it may well be an occupation if the separatist army is in effective control over that territory. So putting this into the context of the Donbas, is the Russian Federation in overall control of the separatists, and are the separatists in effective control of that territory? This is the test that the ICC prosecutor is employing. She's asking the question whether the Russian Federation has exercised overall control over the armed groups in eastern Ukraine. Overall control may amount to less control than effective control. So when looking at the test, when looking at how to assess that test of whether the Russian Federation is in overall control, it needs to be contrasted with the effective control, which is the test for when looking at whether the separatists themselves are in occupation of the East. The overall control test emerges from the International Court for the former Yugoslavia in the Tadic case. Again, it's established on a case-by-case basis with regard to the following such criteria. What is the precise military relationship between the state and the group? Example, what financial, logistical, organizational support and planning, coordination and participation is occurring in and around the military activity. Therefore, in order to determine whether a state such as Russia has overall control over relevant armed groups, the question must be approached by looking at the nature of the group in receipt of any support, the breadth and systematic nature of the support, and the overall extent of the contribution to its activities. This overall control test has been adopted in ECHR cases by the European Court of Human Rights. It's also been adopted by the UN Working Group on Arbitrary Detention. The UN Working Group on Arbitrary Detention looked at this question in relation to whether the South Lebanese Army acted on behalf of Israel. And it assessed what assistance the Israeli state had provided, which included financial assistance through the payment of salaries, logistical assistance, which included such things as building roads to enable the military forces to move. It included professional trainings, whether the Israeli army was training the South Lebanese army. It included such things as cooperation in the release of detainees, the gathering of intelligence, the transferring of information received during interrogations, and the overall coordination of military activities. Having looked at these criteria, the working group established that Israel exercised control over the South Lebanese army and therefore was effectively in occupation. A similar approach was taken at the International Court of Justice in relation to the armed activities case, where the court examined whether Uganda exerted overall control over Congolese insurgent groups. So this is the test. When does an occupation end? It ends, whether it's a classic or an occupation by proxy, with a transfer of authority to the local government, re-establishing the full and free exercise of sovereignty, even if the government agrees to the continued presence of foreign troops on its territory. Now, having dealt with the first question, how the assessment of Russia's alleged occupation of Donbas should be approached, let me briefly move to the second and third questions. The second question, if Russia occupies Donbas, what human rights and humanitarian law obligations does it have? A finding that Russia is in occupation in the East gives rise to a number of obligations. The occupying state is obliged to preserve life and to preserve the life that existed before the occupation, with some specificities. 3 overriding principles should be borne in mind. 1, occupation is a temporary situation. It is not equivalent to annexation. 2, the occupying power has a duty of good governance. And 3, the occupying power may take such measures to ensure the safety and support of its army and the administration of the occupied territory. So first, as established by Article 43 of the Hague Regulations, the occupying power must, as far as possible, restore and ensure security and public life in the occupied territory. Secondly, the occupying power must respect the laws in force in the occupied territory. As such, the occupying power must not repeal, amend, or adopt new legislation in the occupied territory. However, the occupying power does have the right or duty to amend or adopt legislation if such measures are necessary for its own security and to ensure that human rights are enforced and the territory properly administered. Finally, in line with the golden principle of continuity, no fundamental changes should be made to the administrative structures in the occupied territory. For example, Article 54 of the Fourth Geneva Convention states that the occupying power may not alter the status of public officials or judges in the occupied territories. Thus, the occupying power has to respect property rights. There can be no destruction or seizure of property, public or private. The occupying power has to preserve the civilian population. There can be no individual or mass forcible transfers of protected persons from the territory, nor can there be transfer of its own population into the occupied territory. The occupying power must respect social and labour rights. It must comply with its own human rights obligations. In the case of Russia, if Russia is in occupation of the East, then it must comply with the ECHR, the European Convention on Human Rights, and the ICCPR, which, as we know, includes such things as the right to life, the right to liberty, the right to family life, and so on. Russia in Crimea must abide by these human rights obligations, and if it is in occupation of the East, it must also do so there. As I said at the beginning, however, if it is found that Russia is in occupation of the East, this does not remove Ukraine's human rights or humanitarian law obligations. In relation to international humanitarian law, Ukraine still has to comply with norms that regulate the means and methods of warfare, such as the principle of distinction, such as the humane treatment of protected persons, and so on. In relation to its human rights obligations, under the European Convention of Human Rights and the ICCPR, even if Ukraine lacks control over Donbas, it still retains human rights obligations to the citizens in that territory. Obviously, Ukraine may not be able to fulfill some of those obligations due to a lack of control. However, Ukraine should take all possible measures to ensure human rights. The appropriateness and sufficiency of Ukraine's efforts to do so will be decided on a case-by-case basis. At a minimum, though, it will involve Ukraine refraining from supporting the separatist regime and to act by taking all the political, judicial and other measures that it has at its disposal to be able to protect human rights. Finally, the third question: what are the principal legal options that Ukraine has to enforce its the rights against Russia if Russia is an occupying state? If we move to the next overhead. I'm going to be very brief here. This is an in-depth discussion which cannot be dealt with in full today. However, as can be seen by our overhead, there are a number of judicial and quasi-judicial avenues which can be utilized by Ukraine in order to enforce its rights and to ensure Russia sticks by its rights and obligations. Each have their own jurisdictional threshold, each have their own advantages and disadvantages, but each may be used in one way or another to hold Russia to legal account. In this regard, the International Criminal Court remains a very useful court. Unsurprisingly, the ICC prosecutor has already indicated that she considers the Russian Federation to be an occupation of Crimea. She is now examining whether they, the Russian Federation, have exercised overall control over the armed groups in eastern Ukraine. These findings bring into play certain application of the articles of the Rome Statute relevant to armed conflict of an international character. In other words, they create the possibility of holding Russian officials to account for a number of war crimes. So in conclusion, Ukraine has a number of legal options. As noted throughout this presentation, the question of whether Russia is in occupation is a factual question. Therefore, if Ukraine is to use these legal options, the starting point is to conduct a detailed, objective, factual-based assessment of whether Russia is in overall control of the separatists, and if so, what violations have occurred, and if so, how might they be remedied using the available legal mechanisms. Thank you.
Дякую, пане Джордаш. Thank you, Mr. Jordash. Колеги, чи є в когось запитання, можливо? Будь ласка, лаконічно.
Please introduce yourself. Пане Вайне, дуже дякую за те, що надали нам дуже важливу інформацію. Моє питання, я хотів би дуже коротко запитати, чи бачите ви якісь протиріччя між встановленням Росії як окупаційною владою та існуючими мінськими угодами? Що ви думаєте про це? Дякую. Це надзвичайно складне питання. Як я розумію, Мінські угоди, Росія є нейтральним спонсором. І я хотів би подивитися на конкретні деталі Мінських угод, але якщо Росія визначила окупантом Сходу, то тоді тобто дуже незручно бути таким нейтральним спонсором. Якщо Російська Федерація є окупантом, то це тоді ми розуміємо, що Росія відповідає за збройний конфлікт. Це висновок, Тобто вони взагалі контролюють бойові всі дії і за жодних умов важко побачити, яким чином це співпадає з тим, що вони відіграють нейтральну роль як спонсори збройного конфлікту згідно з Мінськими угодами. Це мається на увазі, що сторони конфлікту – це сепаратисти з одного боку та Україна з іншого боку, або український уряд з іншого боку. І це створює досить складну ситуацію. Дякую, пане Вайне. На жаль, у нас більше немає часу, оскільки за декілька хвилин почнеться ще одна подія.